Imagine you've got this brilliant invention, maybe something groundbreaking, like our fictional inventors Anya and Ben with their Neuralink AI. You're ready to go global, file internationally, but then you hit a snag with your legal team. What happens next? Changing your patent agent midstream, especially internationally, can feel really complex. That's exactly the kind of critical, practical detail we're diving into today. Welcome back to the Deep Dive, our series breaking down the MPP, the Manual of Patent Examining Procedure, section by section. We aim to make this stuff clear whether you're studying for the patent bar, you're already practicing, or you just find IP fascinating.
Yep, and today we're in MPP Chapter 1800. That chapter is all about the Patent Cooperation Treaty, or PCT, basically the International Rulebook. And within that, we're zooming in on Section 1808.
MPP 1808. Change in or revocation to the appointment of an agent or a common representative. Sounds formal, but it's super practical.
It really is. It governs how you manage who represents your international patent application.
So our mission today is to unpack all that. Not just what the rules are, but why they matter and how they actually play out. We want you to feel confident handling these representation changes.
Okay, so let's start with the basics. Why does this section even exist? Well, things change, right? Especially during the long international phase of a patent application. You might need to switch lawyers or agents.
Makes sense. So who actually has the authority to make that change? To say, okay, you're no longer representing us?
Good question. The power lies with the original people who made the appointment. So the applicants like our inventors Anya and Ben, or maybe their company, whoever appointed the agent initially, or, importantly, their legal successors.
So the folks who hired them can fire them, essentially.
Pretty much. PCT Rule 90.6 and the U.S. Rule 37 CFR 1.455. Nail this down. If Anya and Ben started with legal firm Alpha but later want patent pros instead,
They can just switch.
they can revoke that first appointment. They just need to submit a properly signed document saying so to the right place. The control stays with the client, which is key. It's their application.
Okay, that's clear.
Yeah.
What about the other way around? Can the agent decide they don't want to handle the case anymore?
Yes, absolutely. Agents can renounce their own appointment. It's not just a one-way street.
How does that work?
They submit a signed notice saying they renounce. And then the International Bureau, the IB, gets involved. They're responsible for telling the applicant, hey, your agent has stepped down.
So the IB ensures the applicant knows what's going on, keeps things transparent.
Exactly. No surprises, ideally. Everyone who needs to know knows.
Now, I heard there's something about appointing a new agent automatically canceling the old one. That sounds efficient, but maybe risky.
Yeah, that's the automatic overwrite rule, as you could call it. It's a really important principle here. Generally, when you appoint a new agent or a new common representative,
Poof, the old one is gone.
usually, yes. The system assumes you want the new person to take over completely, so it automatically revokes any earlier appointments. It simplifies record keeping for the patent offices.
But you said generally. Is there a way around that? What if you want both? Maybe one for U.S. stuff and one for European strategy.
Right, there's a crucial exception that automatic revocation doesn't happen if the applicant explicitly says otherwise.
So you have to actively state it.
Precisely. If Anya and Ben just name patent pros in their PCT request form, that action alone boots legal firm Alpha out. But if they specifically write, we appoint patent pros while also retaining legal firm Alpha, then both stay on.
Okay, so the takeaway is be explicit. Don't assume anything about who's representing you. Clearly state your intention, especially if it deviates from the default override.
You got it. Ambiguity here can cause real problems down the line. Make your instructions crystal clear.
Right. We understand who can make changes and the override rule. Now, the nuts and bolts. Where and when do you file these documents? The power of attorney, the revocation notice.
Okay, practicalities. Usually these documents go to the United States Receiving Office, assuming you filed through the U.S. Think of them as the initial intake point for PCT applications filed here.
And timing. Is there a deadline?
Yes, and it's important. Generally, you need to get this sorted before the International Search Report is issued.
The ISR, that first big assessment of prior art.
That's the one. Submitting changes after that point can complicate things, so prompt action is definitely the best approach. Don't wait.
Makes sense. Get your representation sorted before the substantive examination really kicks off. Now, what about the specific USPTO rules if an attorney wants to withdraw? Are there extra hoops to jump through?
There are. If a U.S. practitioner wants to withdraw, their request needs a couple of key things. First, current mailing addresses for both them and the applicant. Communication needs to continue smoothly.
Okay, Practical details? Anything else?
Yes, ethical obligations. The request has to show they've met their duties under 37 CFR 11.116. That usually means giving the client advance notice, making sure they get all their files and property back, basically handling the departure professionally and ethically.
So it's not just filing a form, it's about responsible conduct.
Absolutely. And remember, any paper filed with the office by anyone comes with a certification under 37 CFR 11.18b. You're certifying that what you're saying is true, knowing there are penalties if it's not. That applies here too.
Right, that underlying accountability for all filings. Okay, here's a tricky one I've seen come up. What if a lawyer tries to formally withdraw, but oops, they were never actually given a formal power of attorney in the first place? Maybe their name was just listed on an application data sheet, the ADS.
Ah, yes, that happens. It highlights a really important point about what constitutes formal representation in that specific scenario because there was no formal appointment via a power of attorney.
The USPTO doesn't need formal permission for them to withdraw.
Correct. Since they weren't formally on the record as the attorney via a POA, the office doesn't process a formal withdrawal request in the same way.
But wait, are they completely off the hook then? What if they did file papers?
That's the crucial part. No, they're not entirely off the hook. Even without a formal POA, if they filed correspondence acting in a representative capacity, they are still accountable for those filings under 37 CFR 1.34.
So listing someone on the ADS doesn't automatically make them the attorney of record with a formal POA.
Exactly. The ADS under 37 CFR 1.76b4 is for informational purposes regarding representation, but it is not a substitute for a proper power of attorney document. You need that separate formal POA to truly establish that attorney-client relationship for representation purposes before the USPTO.
That's a critical distinction. You need the formal POA for clarity on who is the authority to act. Okay, let's talk deadlines again. You mentioned submitting changes before the ISR, but is there a later sort of hard deadline?
There is indeed, and it's a big one. PCT Rule 92-biz comes into play here. Requests to change the appointed agent might actually be denied if you submit them too late in the game.
How late is too late?
After 30 months from the priority date of the application.
Wow, 30 months. That's typically the deadline for entering the national stage in many countries, right?
Exactly. So trying to change your agent right at that very late stage in the international phase might not fly. The system needs stability as applications approach national entry.
So the message again is act promptly. Don't leave representation changes until the last minute.
Definitely. It reinforces that theme we see throughout patent law. Timeliness is key. Missing these deadlines isn't just inconvenient, it can have real consequences. You could potentially need to file petitions or face delays. It's sort of like needing a petition to accept a late priority claim if you didn't make it properly during the international phase. Procedural timing matters.
That parallel makes sense. Now, are these principles about changing agents unique to PCT applications? Or do they pop up elsewhere in patent procedures?
Oh, they definitely pop up elsewhere. The core idea of needing clear, formal documentation for representation changes is pretty universal in patent practice.
Can you give an example?
Sure, think about post-grant proceedings, like re-examination or supplemental examination. If the patent owner wants correspondence for that specific proceeding to go to a new attorney, not the one who handled the original patent.
They need to file a new power of attorney.
Yes, and importantly, they often need to file it in two places, in the file for the original patent and in the separate file for the re-examination or supplemental examination proceeding itself.
Why both places?
Because they're distinct records at the USPTO, even though they relate to the same patent. Filing in both ensures everyone looking at either file knows exactly who is authorized to receive correspondence and act for that specific matter. Prevents confusion.
And does the USPTO offer guidance on how to do that?
They do. They strongly encourage using their specific form, PTO AIA81B, for powers of attorney or changes of correspondence address in these post-grant situations. Using the standard form helps ensure you've included all the necessary info.
So consistency and using the right forms are key across different types of proceedings.
Absolutely. And even internationally, while some requirements might be waived generally, specific bodies like an International Preliminary Examining Authority might still occasionally ask for a separate POA or a copy of a general POA. So always check the specific requirements.
Wow. Okay. We have really covered a lot of ground in MPP 1808 today. We've gone from who has the power to change representation to agents renouncing that automatic overwrite rule.
The timing and location for filings, the specific withdrawal rules in the U.S., including those ethical duties, and the nuance about acting without a formal POA.
Right, and that crucial 30-month deadline, plus how these ideas apply beyond just the initial PC filing, like in re-exams, we really unpack the management of agents and representatives.
We did, and understanding this, well, it's vital. Whether you're like Anya and Ben just starting out, maybe prepping for the bar exam, or you're a seasoned pro managing a global portfolio, or even just an IP enthusiast, getting these procedures right is crucial.
Yeah, it avoids delays, ensures clear communication, and ultimately protects the integrity of the whole patent prosecution journey.
Couldn't agree more.
So here's something to think about as we wrap up. We live in this incredibly connected world. Innovation like Neuralink can come from anywhere and aim for global impact. How might technology, maybe AI or blockchain, further streamline these complex international processes for managing legal representation?
That's interesting.
And maybe what new challenges could arise, like ensuring secure, universally accepted digital identities for legal representatives across all these different patent offices and legal systems. Something to ponder.
Definitely food for thought on the future of global IP management. Now, the necessary reminder, this deep dive was put together with help from AI tools. It's for general educational info only.
That's right. It's not legal advice. It's not a substitute for formal training. For the official word, always go to the actual MPP, consult a qualified instructor, or speak with a registered patent practitioner.
And a huge thank you, as always, to Mike Sheppard, the creative director behind this entire MPP audio series.
Thanks for joining us for this deep dive into MPP 1808.